Again, good morning. This is Board President Dr. Vasco Dion Kidd on the California Physician Assistant Board. I would like to call the meeting to order at 8:30 a.m. on April 21st, 2025. Ms. Herr, will you please call the roll?
Good morning. Juan Armenta, Eric Bergeson,
Present.
Philip DeVizio, Diego Insunza,
Present.
Vasco Dion Kidd,
Present.
Edwin Perez,
Present.
Bhavna Prakash,
Present.
Deborah Snow, Viling Sai.
Here.
And that completes the roll call.
We have a quorum. Thank you so much, Ms. Pearl. The first item on the agenda is the consideration and approval of the November 8th, 2024 board meeting minutes. I trust that everyone has had the opportunity to review those minutes. Are there any additions or corrections from the board members? Hearing none, is there any public comment here on the floor or on WebEx?
Good morning. This is the moderator. For public comment, I'd like to always start with public comment in the room, and then we'll go on to WebEx. Are there any, so is there no request for public comment in the room?
That's correct.
Okay, so I'm opening up the Q&A panel. If any member of the public would like to comment on agenda item 3, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We'll give you a moment. All right, I see no request for comment at this time. Mr. Board President, I return the floor back to you.
Thank you so much. I will entertain a motion to approve the November 8th, 2024 board members minutes. Anyone like to make a motion?
Yeah, I'll make that motion, please. Sorry. I'll go ahead and make that motion to approve the minutes.
Is there a second?
I'll second.
Okay, thank you.
Sorry, was that Diego that second?
He is the second. Yeah, so that motion stands approved. Now we could, yeah. Do we have any public comments on WebEx?
Thank you, Mr. Board President. I am opening up the Q&A panel. If any member of the public wishes to comment, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We'll give you a moment. All right, I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. Ms. Herr, will you please call the roll for vote?
Yes. Juan Armenta,
Aye.
Eric Bergeson,
Aye.
Philip DeVizio,
Aye.
Diego Insunza,
Aye.
Vasco Dion Kidd,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash,
Aye.
Deborah Snow. Deborah Snow is absent.
So the motion stands approved. Okay. So moving on to item number 4, public comment on items not on the agenda. Please note the board may not discuss or take any action on any matter raised during the public comment section that is not included on this agenda, except to decide whether to place the matter on the agenda for a future meeting. Are there any comments on WebEx?
Thank you, Mr. President. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 4, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Mr. Board President, I return the floor back to you.
Thank you so much. So we're going to go out of order to address agenda item number 10. Some of our DCA staff need to return back to the office for time-sensitive projects that they're working on, and then we will circle back to agenda item number 5. It's good to see you both.
Good morning. For those of you who don't know. Okay. Good morning. My name is Andrew Trudy. I'm a budget analyst with the DCA Budget Office. I'm here alongside Suzanne Balkus, budget manager. I want to thank the board and the executive staff for allowing us time to present the board's expenditure and revenue projections, as well as the fund condition statement. Please refer to agenda item 10 of the packet, in which the first page is the board's expenditure projections. We are presenting FM8 expenditure with estimated May revise and additional augmentation. We are estimating $1.511 million in personnel services and about $2.334 million in OE&E expenses for a total of about $3.795 million, which has created a surplus of about $1,000 or under 1%. We are monitoring the fund and have been taking action to protect the board's solvency. The Budget Office will continue to monitor these expenditures and report back to the board with monthly expenditure projection reports as future fiscal months close. Next page is the revenue projections. We have an end of year projection of $3.188 million against an estimated revenue budget of $3.013 million. We have no concerns about revenue, but will continue to monitor and update the board with monthly projection reports. Next page is the fund condition statement. The fund condition gives you a 5-year view of the board's fund, and I will speak to each section top to bottom and left to right. The first column includes prior year actuals, 23-24 actual beginning balance of about $4.2 million with a prior year adjustment of $15,000. That gives us an adjusted beginning balance of about $4.2 million. Collected approximately $3 million in revenue with total expenditures of $3.3 million. That gives a fund balance of about $3.92 million or 11.8 months in reserve. Next is the second column, current year, which is 24-25, which includes FM8 projections, AG, OAH, and enforcement augmentations, and is based on an estimated May revise. The board has a beginning balance of about $3.92 million. The board projects an estimate of $3.19 million in revenue and $3.975 million in total expenditure. We currently have a fund balance of about $3.135 million, which gives us about 11.3 months in reserve. In the next 3 columns, we have 25-26 budget year through 27-28 budget year plus 2 projections. These projections are based on estimated May revise, except for the income from surplus, which is formula driven. A few things to note about the board's fund condition. The fund condition is a snapshot in time and thus only a reflection of the data used in its creation. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases, or GSI, as well as an employee compensation and retirement rate adjustments. The Budget Office includes an ongoing 3% increase to expenditures on the FCS to account for these ongoing incremental adjustments. Fund condition does not include increased enforcement expenditures, which could create additional cost pressure to the board's fund in out years. The Budget Office will continue to work with the board on any future resource needs. Months in reserve will always go down in out years as we project revenues to remain constant and expenditures to increase by the 3% mentioned previously. And lastly, we would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would increase pressure on the fund. The Budget Office will continue to monitor the board's fund condition statement and keep the line of communication with the board's executive staff open for any future needs or expectations. That concludes our presentation, and we are happy to answer any questions. Thank you.
Thank you. Great presentation. And I think you just answered my question, but I'm going to just cite it here for the rest of the board members. Regarding the fund balance, months in reserves, I noticed that we were projected to trend downward from 11.8 months to 7.8 months. But I would assume there will be an adjustment based on actuals and incremental revenue from fee increases. Is that correct?
Yes, that is correct.
Okay. Thank you so much. Are there any questions from the board members?
Just a comment. So for clarity, I think we understood that, but these calculations do not place in there right now what we hope and expect will be fee increases, correct?
No, it's not including any fee increases.
Right.
Okay.
Okay. One question. What is the can you give me a further explanation of the 193,000 and the 375,000 for AG augmentation and allied health? Can you give us a little better
Yes.
understanding?
So this current fiscal year, the board was overexpanding in their enforcement costs. And so we had to request an AG and OAH augmentation to offset this cost. That's for the 193. For the 375, it's also enforcement costs, but it is due to increase in allied health cases. And so that's why we needed to request additional augmentation to offset these costs.
Very good. Thank you.
Just to go back to that point, so I think we're spending over 50% of our overall budget on enforcement activity. Is that correct?
That's correct.
Okay, that would make sense for the augmentation, right?
Yeah.
Okay, thank you. Any other questions from board members or comments? Thank you so much. Well, thank you for that great presentation. Appreciate
Thank you
that.
for your time.
All right, moving back to agenda number 5, introduction and swearing in of new and reappointed board members. This is, I think, a really great opportunity to welcome. It is my honor and privilege to welcome 4 new board members and 1 reappointed board member to the California Physician Assistant Board. And I look forward to their engagement and partnership in helping the board carry out its public protection mandate. Did I need to take public comment regarding the budget analyst report?
Yes, we should have. It was that.
Yeah, so let me do that. So is there any, so let me just go back here. Is there any public comment on WebEx regarding the budget analyst report?
Thank you so much. I have opened up the Q&A panel. If any member of the public would like to comment on agenda item 10, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
Thank you so much. So circling back to agenda item number 5, let me just repeat that. Introduction and swearing in of new and reappointed board members. We have 4 new board members to replace 4 outgoing board members, and we also have a reappointed board member. So very exciting. So I've met with each board member. We're going to kind of read their bios here really quick, and then I will have them go to the front where I would administer the oath of office. So we'll start with Mr. Philip DeVizio. Mr. Philip DeVizio has been a supervising physician assistant at hospital, lead physician assistant at Kaiser Permanente since 2016, an assistant professor at A.T. Still University College of Health Sciences since 2021. He was an emergency medicine physician assistant at Envision Healthcare, Dameron Hospital Emergency Department from 2018 to 2023. Mr. DeVizio was a regional physician assistant director at Valley Emergency Physicians from 2011 to 2014. He was a physician assistant and site director at Valley Emergency Physicians from 2004 to 2017. Mr. DeVizio is a member of the Society of Emergency Medicine Physician Assistants, California Academy of Physician Associates, and the American Academy of Physician Associates. He earned a Doctorate of Medical Science degree in Healthcare Administration and Management from the University of Lynchburg, a Master's of Science degree in Physician Assistant Studies from A.T. Still University, and a Bachelor's of Science degree in Physician Assistant Studies from Kettering College of Medical Arts. Next new board member is Eric Bergensen. Eric Bergensen of Long Beach has been the Regional Medical Director at Bicycle Health Medical Group since 2020. He was the APC Director at VEP Healthcare from 2018 to 2020. Mr. Bergensen was an emergency medicine physician assistant at VEP Healthcare, a lot of acronyms here, from 2017 to 2019. He was a clinical consultant at Guyant from 2018 to 2019. Mr. Bergensen was the lead emergency department technician at Beth Israel Deaconess Medical Center from 2012 to 2015. He is a member of the Physician Assistants in Virtual Medicine and Telemedicine. Mr. Bergensen earned a Master's of Science degree in Healthcare Administration from Oklahoma State University, a Master's of Science degree in Physician Assistant Studies from George Washington University, and a Bachelor's of Science in Behavioral Neuroscience from Northeastern University. Next board member, which is a public member which is Ed Perez of Sacramento, was a manager at Labor Relations and Performance Management, California Department of Water Resources from 2019 to 2024. He was a labor relations specialist, Department of Water Resources from 2015 to 2019. Mr. Perez was a labor relations specialist and labor relations analyst at the California Department of Corrections and Rehabilitation from 2013 to 2015. He is a member of the Asian Pacific American Public Affairs Association, the Hamptons Community Foundation, the Hamptons Owner Association, and Garland Northgate Neighborhood Association, and a community activist with the AARP. And make sure that I say this name correctly here. Bhavna? Okay, Bhavna Parkesh of San Jose has been a physician assistant and program manager for the Adult Congenital Heart Program at Stanford's Children's Health since 2024 and a supervising physician assistant at the Permanente Medical Group since 2015. She is a member of the American Congenital Heart Association. Ms. Parkesh earned a Doctor of Medical Science degree from A.T. Still University, a Master's of Medical Science degree from St. Francis University, and a Master's of Science degree in Physician Assistant Studies from Stanford University. We have some very qualified folks here on the board, so I'm pretty excited about that. All right, so now we're going to begin the process of the oath of office. So I will start with, I think it's, let's see, make sure I have that correct. Yeah, it should be on the top. Yep, right here. Okay. So we will start with Mr. Diego Azusa. Would you like to come to the front? Raise your right hand. Solemnly swear that I will support the Constitution State of California
And the Constitution of the State of California
against all enemies,
against all enemies,
foreign and domestic. I will bear true faith and allegiance to the Constitution
and allegiance
of the United States
to the United States
and the Constitution
and the Constitution
of the State of California.
of the State of
That I take this obligation
that I
freely, without any mental reservation
without any
or purpose of evasion. That I will well and faithfully discharge the duties
discharge of the duty
upon which I am about to enter.
upon
Welcome to the board. Smile. Mr. Perez. I.
Aye.
Thank you. I, Ed Perez,
I, Ed Perez,
do solemnly swear
do solemnly swear
that I will support and defend
that I will
Good morning. This is the moderator. May I have the members of the public who are logged into this meeting please raise their hand if they are no longer able to hear or see the meeting? All right. Thank you.
Okay, thank you, sir.
Thank you. Appreciate that. All right, Mr. Bergensen. I, Eric Bergensen,
I, Eric Bergerson,
do solemnly swear
do solemnly swear
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies,
against all enemies,
foreign and domestic,
foreign and domestic,
that I will bear true faith
that I will bear true faith
and allegiance
and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California.
and the Constitution of the State of California.
Take this obligation freely,
I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well
and that I will well
and faithfully discharge
and faithfully discharge
the duties upon which I'm about to enter.
the duties upon which I am about to enter.
Congratulations. Welcome to the board.
Would you mind doing for,
Mr. President, Michael Canotza, legal counsel. We do have an audio recording. It's probably a good reason to keep making those. So what we did happened at the board meeting, for folks at WebEx, you missed one of the introductions, but I think we can carry on with the meeting now.
Yeah. I may just go back and just do that introduction. Yeah. Yeah, just one more quick introduction. Mr. Diego Azusa of Castro Valley was reappointed by Governor Gavin Newsom to the Physician Assistant Board, where he served since 2020. Mr. Azusa has been a physician assistant in the Department of Plastics and Burn and Reconstructive Surgery at Santa Clara Valley Medical Center since 2022. He was a physician assistant in the Emergency Department at Santa Clara Valley Medical Center through the United States Acute Care Solutions, VEP Healthcare, from 2018 to 2022. He was a physician assistant at the University Medical Partners from 2021 to 22. He was a group supervisor with the San Mateo County Probation Department from 2015 to 2019. Mr. Azusa was a medical translator at the Santa Clara County from 2012 to 2016. He was a community outreach coordinator for the city of San Jose, vice mayor from 2010 to 2014. Mr. Azusa is a member of the California Academy of Physician Assistants and the American Academy of Physician Associates. He earned a Master's of Science degree in Physician Assistant Studies from Samuel Marriott University and a Bachelor's of Science degree in Health Science from the University of California, Santa Cruz. Is there any public comment on the floor or on WebEx?
This is moderator. If there's no public comment in the room, I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 5, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We'll give you a moment. All right, this is the moderator and Mr. Board President. I see no I do see a request. So a member of the public identified as Hina has a comment, and just a reminder, you'll have 5 minutes with a 30-second warning. Hina, you should be able to unmute. All right. So Hina, if you see a prompt to unmute, go ahead and do that. All right, I don't think Hina is able to unmute. She did type in the Q&A, congratulations and great panel. So with that, I return the floor back to you, Mr. Board President.
Thank you so much. And it is, again, an honor and privilege to welcome the new board members as well as our reappointed board member as well. Looking forward to your engagement and working with you in fulfilling our public protection mandate. We're going to go ahead and now move to agenda item number 6, the president's report.
Make a comment. So I am the vice president, was a past president, and I remember when I first came here, I had the same question of Bob Sachs, who was a longtime member. And the question may go for you guys too, is, what is my function here? You know what? You're here for your opinions. Give them freely. That's why you were appointed, for your expertise and your opinions. Don't be shy. Get them out there.
Very good advice, and you will find that all of us have quite a bit of opinions about a number of issues, a range of issues. And so we're going to be discussing some of those opinions today and more likely in subsequent board meetings, but great advice. Thank you, Mr. Armenta. So moving on to President's report, agenda item number 6. I regularly meet with the Vice President Juan Armenta and board staff virtually to discuss board business and initiatives. I greatly appreciate their engagement and valuable input during these meetings. Regarding our recent joint sunset hearing, it was an honor and privilege to present on behalf of the Physician Assistant Board at the Joint Sunset Review Oversight Hearing held by the Senate Business, Professions, and Economic Development Committee and the Assembly Business and Professions Committee in Sacramento, California. For the benefit of our new board members, like other boards within the Department of Consumer Affairs, the Physician Assistant Board undergoes a sunset review every 5 years. I was joined at the hearing by our outstanding board staff, Executive Officer Rosanna Kahn, Assistant Executive Officer Christy Voon, and Legislative and Regulatory Affairs Specialist Jasmine Dillon. The sunset report presentation was well received by the committee members. In fact, we were told that we got an A+ on our presentation, so we're pretty excited about that. Topics discussed during the hearing included PA to physician supervision ratios, access to care, and the use of artificial intelligence in healthcare, and much more. One of the questions I was asked towards the end of the presentation focused on practice agreements. Is the board tracking efforts in other states to expand access to care by removing requirements for a written practice agreement? If so, has the board developed any conclusions, recommendations, or thoughts? So we have not discussed that issue at the board, but we will be discussing that issue in August when I will be presenting some data to board members, and I hope to have a very rich discussion about that because the committee had asked for us to kind of take a look at that. And I did mention that we had not had any formal deliberations on that or discussions, but that we would have that in subsequent board meetings. So be prepared for that in August, and that will be one of the agenda items that we will look to add. A special thank you to the Sunset Review Committee and their staff for the opportunity to discuss the board's work and future initiatives. We sincerely appreciate their time, thoughtful questions, and commitment to effective oversight. I look forward to continued collaboration with the California Legislature. Regarding board meeting dates, we have historically met 4 times a year, but due to state budgetary concerns, the number of meetings we will propose to be reduced from 4 to 3 per year starting in 2026 to help reduce board travel cost. Lastly, I'd like to inform the board of recent changes to the committee names and structure. The Legislative Affairs Committee has been renamed to the Legislative and Regulatory Affairs Committee. The Education Workforce Development Advisory Committee is now the Physician Assistant Training, Accreditation, and Workforce Development Committee. And we just formed a newly budget committee that has been recently established where the vice president and I sit on the budget committee. I will be asking for volunteers to join the other 2 committees. It is on a first come, first served basis. So if you would send me an email, we can certainly discuss the committee's overall vision and charter, and we can kind of see what your interests are and go on from there. So if you have an interest, reach out to me. And this will conclude my report. Are there any comments or questions from the board? This is a quiet group.
Well, let me fix that. So you indicated that you had planned to supply data for the August discussion. I would ask that you get that data to us at the earliest possible convenience, so we have some time to sort it out to give a more robust discussion.
Absolutely. And I think if we remember the physician to PA ratio, I published an article that I think we submitted. So if I do something similar, but I will make sure that we do get data out to the board and disseminate it to you well in advance of the August meeting. Thank you, Mr. Armento. Are there any comments on WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 6, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We'll give you a moment. All right, I see no further requests for comment. Mr. Board President, I return the floor back to you.
Thank you so much. All right, moving on to agenda item number 7, Executive Officer's Report. Ms. Khan.
Good morning, everyone. Can you hear me? Yep. I'll start off with personnel. The board is pleased to report that it is fully staffed with 11 authorized positions and no current vacancies. The second item is on January 29, 2025, Governor Newsom issued Executive Order N-15-25, which postponed for a period of 1 year renewal fees for any licensee with an expiration date occurring between January 1st, 2025 and July 1st, 2025, and whose residential or business address is within the impacted zip codes. Additionally, the order waives fees for duplicate or replacement licenses and provides that such replacement licenses shall be issued free of charge through January 7th, 2026. It also suspends delinquency fee, late and penalty fees associated with renewals for eligible licensees through July 1st, 2025. Board staff worked with Department of Consumer Affairs, DCA, on the implementation of the executive order. It is important to note that renewal fees are not being waived. Rather, payment may be deferred for up to 1 year. At this time, the impact of these temporary deferrals and fee waivers on board is expected to be minimal. The board has shared this information along with available resources on its website and social media platforms to help ensure the licensees are aware of the relief available under the executive order. The next item is Executive Order N-22-25, Return to Office. On March 3rd, 2025, Governor Newsom issued Executive Order N-22-25 requiring all agencies and departments under his authority to implement a hybrid telework policy with a default minimum of 4 in-person work days per week, effective July 1st, 2025. Following the issuance of the executive order, board staff submitted information to DCA leadership regarding the logistical implementation of the return to office mandate. This included confirmation that the board has sufficient space to accommodate the increase in in-person work and can support all current employees being in the office 4 days per week. Next item is the Controlled Substance Utilization Review and Evaluation Systems CURES update. Effective July 1, 2025, CURES fee increased from $9 to $15. DCA's Office of Information Services, OIS, has implemented the updated fee into the BREEZE system. Additionally, DCA has distributed an outreach toolkit, and the board has shared information about the CURES fee increases on its website, social media platforms, and through its listserv to ensure board awareness among licensees and stakeholders. Lastly, on April 15, 2025, board published its spring 2025 edition of the Biannual Insider online newsletter. This interactive communication tool is designed to keep applicants, licensees, and consumers informed by sharing updates, relevant board-related information. That concludes my report.
Thank you, Ms. Khan. Are there any questions from board members? Hearing no questions or comments, is there any comments on WebEx?
Thank you, thank you, Mr. Board President. I've opened up the question and answer panel. If any member of the public would like to comment, please raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Mr. Board President, I return the floor back to you.
Thank you so much. And again, Ms. Khan, thank you for that great report. Let's move on to agenda item number 8, board activity reports. Licensing will be with Ms. Caldwell.
Morning.
Good morning.
Looking forward to getting to know everyone. Thank you. My name is Julie Caldwell. I'm the lead licensing analyst for the Physician Assistant Board, and I have the pleasure of reviewing the reports with you. They're in your packet, starting with agenda item 8A. Can't see anymore, so I'm going to have to put the ugly readers on. Okay. So the licensing population by type, that breaks down our licensing population into different categories from current all the way to canceled, surrender, revoked. Currently, that total is 19,007 licensees are current status, and we have a total of 27,970 licensees with various statuses. Any questions about that report?
That's a significant uptick, right? Because I think we had 18,200, right? Which represents a significant increase since our last sunset review. So that's outstanding. I think we're the second largest state of PAs in the country.
We continue to grow at
Yeah,
a great rate.
Yep.
So, yeah.
Thank you.
Yep. Okay. So page 2 of agenda item 8 is the summary of the licensing activity. And what that does, it gives you an overall view of what transpired between October 1st of 2024 through March 31st of 2025. And during that time, we had 1,094 applications for an initial license. And the initial license, the name of it can be a little misleading. We do have individuals who have been licensed in California previously, and we have one type of application, which is the initial application for licensure. So if their license cancels, they do reapply with the initial application for licensure, even if they have had a previous license. And then we approved 1,117 applications for licensure. And then we had 4,396 individuals renew their license during that time period. Any questions on that?
Quick question. During license renewal, do we require that they indicate or some attestation that there's a practice agreement on file at their location?
No,
We don't.
we
Okay.
do not. Yes.
Good morning. Thank you, Julie.
Uh-huh.
Want to go back to the prior
Sure.
slide. So this is a significant increase. I was looking at this morning, and I think when I started here, that was in the 12s. So it's been a significant change. I don't want to add more to your plate, but how difficult is it for you to do a comparison with some of the other larger states in terms of comparing our growth? Because when we have this discussion in August, I think that will be a very useful piece of data.
I think it would just depend upon what information is available on their public site as far as, how their information is displayed and available to the public. And if I could reach out to the individual states, probably need just do a little
Could I
digging.
ask for that to be done? Is that too much to ask, Rosanna?
So just really quick. So the NCCPA actually publishes data state by state
Okay.
and looks at population growth of PAs, those that are in primary care versus those that are in subspecialties. It gives you a wide range of data points. I can go ahead and submit that report. That might give you the information that Juan is requesting because it's kind of a state by state comparison of PAs, and it's a very rich data set that they use.
Perfect.
That they publish because they take licensees or really certified PAs. So there's a little bit difference because not every licensee is certified. There's some PAs that are certified and those that are not, but it will give you, I think, a clear snapshot as to what the population growth is. I'll submit that report to you.
Okay. And what we can do is build on that by going to the individual states that have a higher percentage of population for
Correct.
PAs, just to see if there's a big difference between the certified versus non-certified. We do have a significant portion of our licensees that are certified by the NCCPA, but because we are one of the states that don't require it, we do have people during the last 9 months of doing the CME audits. We do have a considerable amount of people that are not certified just from that small 5% per month of auditing. You know, I will end up with probably 3. I know that doesn't sound like a lot, but you know, that's just the 5% that are actually being selected for audit. So we can do that too. We can try and, you know, narrow the window of, or unless that's not important.
I don't know how deep a dive, I guess what I'm looking at for some fixed data points are our growth relative to other states.
Okay.
As far as I think
right.
that would be useful.
Great.
Okay.
And just a point of clarification. So we do require certification for initial licensure, but not maintenance of licensure, right? So
You're required to pass the PANCE.
Correct.
So it's not certification at that time. So if you're newly graduated and taking the PANCE, yes, you're certified.
correct.
But if you've been a PA for 10 years, you may not be certified. So we ask for you to submit or release the authorization of your PANCE score. So it doesn't necessarily mean you're certified still.
No, so we're saying the exact same thing. So when a PA graduates or a PA,
Mhm.
they have to pass the PANCE, right?
Correct.
The Physician Assistant National Certification Examination. Once they pass that, they're eligible for licensure within the state of California, but they're not required to maintain certification right after initial licensure.
Correct. But I heard it as they have to be certified when they apply for a license. And we do have a significant amount of individuals that apply that have been PAs for a while, and they may not be, we don't have any question on our application of whether or not you're certified. So the requirement is just to authorize the electronic release of your PANCE score, regardless of where you're at with your certification
Correct. So
cycle.
initial
Yeah.
licensure, if you're a new grad coming in would
Yeah,
be
pretty much.
certification,
Yeah.
and then relicensure after you've been licensed, not a
Yeah,
requirement.
exactly. Yep.
And I just did that for the board members, Ms. Coleman.
Yep.
Thank you so much. Are there any other questions or comments from Ms. Caldwell?
I don't think she's finished.
No, you're still going?
Okay. So page 3 of agenda item 8 is the pending application workload.
Okay.
That just gives you an overall view of about how many applications we have pending currently. And so we do have a system where you can apply through the Breeze system. And we have staff that go in and assign the applications to our licensing analysts. So there's a little bit of a difference between the desk age and the application age. And that's what the difference is about. There's a little key down at the bottom, but that just gives you kind of at a glance that we have about 411 individuals that are have submitted applications and are pending licensure. And then the licensing performance measures, which is the last page of the application, that gives you an idea of our target. So our target is to provide the initial review for each and every application that's submitted within 30 days. And they do receive an update. The majority of the time it's by email. Sometimes we still have individuals, so don't provide their email address. We do reach out to them and ask for them to provide their email address because it definitely helps expedite the communication process. But typically within 30 days, the applicant is provided with an update to let them know what is deficient. And then within about 7 business days of receiving that last item, they receive their license. So licensing typically is about a 30 to 45 day window, barring no unusual circumstances, and that would include maybe the failure of passing the PANCE, difficulty getting a verification. We do accept verifications electronically, so sometimes it's just a delay in that specific state that's supporting or sending the verification to us. Sometimes there's information on the criminal history record check that we have to address, and that takes a little bit of extra time. So that's what's causing the incomplete application information on that report, is that it's not because we haven't reviewed them and let them know where they're standing. It's because we just don't have all of the documentation that's needed for licensure. Okay.
Quick comment. So given the development of all the PA programs that we have, and I'm going to be giving a report on that shortly, do you see a significant uptick in the number of folks that are applying that don't necessarily have all their documentation complete? And then is that a concern in terms of personnel and resources and workload?
No, I think
Okay.
it just varies, you know, I mean, we do get a influx of applications at the end of a program, you know, getting ready to graduate from that PA program. Majority of those individuals typically might not have the PA program certification form as evidence that they've successfully completed their program in their pants. But it's not unusual for us to have somebody be delayed, but that we've had an influx, I feel like lately, of individuals that are working for like their traveling PAs. So they've got, you know, 20, 25 state licenses, and that can actually delay them a little bit with licensure, but that's not an unusual situation. You know, I think if you have that many licenses, you're going to have a little bit of a delay getting all of the documentation to us, but the majority of people, we do have quite a bit of stuff by the time they get reviewed, because they can start working on submitting all of their documentation. They can even do it before they apply. So when I do a licensing presentation for a school, I do tell them, if you're within a couple of months of graduating and you've got a certain type of certificate that I and our staff understand that it takes a little bit of time to get that verification for, I will encourage them to go ahead and request that, because we can hold on or reserve that document for a year pending the receipt of an application, and then vice versa. So we get an application, the application's open for a year, pending the receipt of all of the required documentation. So it's not typical that, you know, we haven't gotten something and that's delaying somebody significantly, because they have that 30 days of wait time anyways. And by that time, it's usually just the PANCE or the program certification that we're missing.
Thank you.
Any other questions? All right, enjoy the day.
Thank you, Ms. Caldwell. Great presentation. Moving on to item number B, complaints. Ms. Serrano.
Good morning.
Good morning.
Good morning, board members. Welcome to the new board members. My name is Linda Serrano, and I am the complaint analyst, and I will be reporting on our enforcement. I will be reporting on the complaints for second quarter and the third quarters, which is October 1st, 2024 through March 31st, 2025. And as you can see in the charts provided to you, you guys also have the stats for the prior year. And these reports will show how we are trending from last fiscal year to the current fiscal year. So the complaint volume. For quarter one, we received a total, for quarter two, we received a total of 134 complaints. For quarter three, we received 162 complaints for a total of 296 complaints. For convictions and arrest, for quarter two, we received 12. And for quarter three, we received 12 for a total of 24. So grand total of complaints received were 320 complaints for both quarter two and three combined. On intake, we have an average of 5 days, and currently we have 0 complaints that are pending at intake. For complaints and investigation, complaints that were referred for investigation, for quarter two, we had 38. For quarter three, we had 29, for a total of 67. And complaints and investigations that were closed, for quarter two, we had 197. And for quarter three, we had 183 for a total of 380 closed complaints. Currently, we have 292 complaints at the desk analyst, which is myself. And then at the investigations, which are pending at the investigation, there's 72. Now, in regards to the investigation aging, the average age of pending investigations are about 187 days. And investigations over 8 months old, we have 19 cases. And then we provided 2 charts for you for review. The second chart is regarding the type and source, complaints received by type and source. And this completes my report. If you have any questions.
Thank you so much for that outstanding report. Any questions from the board or comments? Hearing none. Thanks again. Really appreciate it.
Thank you for your time.
Moving on to item number C, discipline. Ms. LaForte.
Good morning, everyone, and
morning.
welcome the new members. My name is Christina Lafort. I'm the discipline analyst for the board. I'm going to present to you the discipline statistics. Report number C. So this is for fiscal year 24-25. We're reporting the second quarter, which is October 1st, 2024 to December 31st, 2024, and the third quarter, January 1st, 2025 through January 31st, 2025. Onto the section of suspensions. For the second quarter, there was one interim suspension order. And for the second quarter, there was one Penal Code Section 23 order. And the third quarter, there was one. For the Office of the Attorney General transmittal, for the second quarter, there were 5 cases transmitted for the second quarter, and the third quarter, there were 11. For the cases pending, there in the second quarter was 39, and the third quarter, 46. For the average age of the pending cases is second quarter, 475, and the third quarter is 459. For the formal actions filed, withdrawn, and dismissed, the second quarter, there were 5 accusations filed. For the third quarter, there were 6. For accusation and/or petition to revoke probation, there was 1 filed in the third quarter. For the accusations withdrawn and dismissed, there was 1 in the third quarter. For the petition to compel physical and psychiatric exam, there's 1 in the third quarter. So on to the next page, administrative outcomes and final order. There were, for the probation, the second quarter, there were 2. For the third quarter, there was 1. For public reprovals, the second quarter, there were 3. And for the third quarter, there was 1. And the license revocations, there was 1 in the second quarter. And for the license surrender, there were 2 in the third quarter. I'll move on to the citation and fine. The second quarter, there were 10 citations issued. In the third quarter, there were 25. The citations withdrawn, the third quarter, there were 5. And for the citations resolved and closed, I'd like to make a correction to that. The numbers that are there were, in the second quarter, there were actually 14 resolved. And in the third quarter, there were 8 resolved. And for the pending, there's 4 in the second quarter. And for the third quarter, there are 13. For the fines issued in the second quarter, it's $3,750. And in the third quarter, it's $7,000. For the fines withdrawn in the second quarter, it was $500. And for the third quarter, it was $1,750. So for the fines received in the second quarter, it is $5,250. And in the third quarter, it's $2,750. And that concludes my report. Does anyone have any questions? Yes.
So with your corrections, it looks like the resolved close is considerably higher than the 67% here on this spreadsheet.
Yes, I didn't have time to check to update it.
Okay. Is that a trend you think you're seeing by your efforts to get closure faster, or any things we've changed in the past couple of years? What do you think?
So I think, with the closures and the resolves, a lot of times, I'll send out emails once the citations are issued. We send out emails, or, I contact them by phone, and I kind of have to stay on top of that, like just to make sure that it gets resolved. There's times where we won't hear from them for a few months, but I do my best to reach out to the licensees. If we have an email, I'm able to contact them. So it really differs from time to time.
All right. Well, that's a good trend in that direction.
Yes.
Like that. Okay. Thank you.
All right. Thank you, Ms. LaForte. Any other questions? No, thank you. All right. So we're going to move on to item number D, probation. Ms. Gerard.
Good morning.
Good morning.
Welcome to the new board members. I'm Virginia Gerard. Ginger, I'm your probation monitor. I'll be reporting on the last 6 months. So in the second quarter, we had one licensee who passed away. We had 2 folks had an effective date. That means they began probation during that time. We had 3 people successfully complete their probation terms. We had 1 person who was revoked. And that person was tolling, which means they were not practicing in California and they may have been out of state. So we ended that quarter with 34 active, 7 tolled, with a total of 41. This 3 months after that, we had 1 person enter probation, 2 successfully completed probation. We had 2 people voluntarily surrender, and those people were also told. So we're whittling that number down. And we have ended with 33 active probationers and 5 told. Are there any questions regarding the probation report?
Just real quick for the new board members, even if they complete or if they finish the term of their probation but haven't paid back their fine, the probation still continues until the fine is paid back. Is that correct?
That's correct. I wouldn't report them as having completed.
Gotcha.
Yes, sir.
Thank you. Any additional questions or comments from the board? Okay. Well, Mr. Rod, while we have you here, why not just do diversion?
Yes, sir. So diversion, we had 1 person successfully complete in October, and that person also was one of the numbers that successfully completed probation.
Okay.
And then we gained somebody in November. After that, the participants are the same. In January, we did get a new vendor. The name is Premier Health Group. And so we had a vendor for a number of years before, so we switched. And that concludes my report. And if there are any questions.
The vendor before, was that Maximus?
Yes, sir.
Okay.
Any additional questions or comments for Ms. Gerard? Thank you so much for your report.
Thank you, Mr. President.
Thank you. Are there any public comments on WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 8, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and we'll give you a moment. All right, I see no request for comment at this time. Mr. Board President, I return the floor back to you.
Thank you so much. Moving on to agenda item number 9, Department of Consumer Affairs Director's Update, DCA staff.
Good morning.
Good morning.
Well, thank you for the opportunity to present the DCA update. Before I begin this morning, I would like to welcome our newest members. I'm going to try and, excuse me if I mispronounce any of these names. Member Burgesson, Divizio, Perez, and Prakash to the Physician Assistant Board. In addition, I'd also like to recognize Diego Inzunza for your reappointment to the board. Lastly, I'd like to express thanks to all the members for filing your Form 700s by this year's April deadline. By doing so, it helped the department achieve compliance with the FPPC's 2025 filing requirements. Okay, my first item this morning is on the governor's reorganization plan. In January, Governor Newsom released his proposed 2025-26 state budget, which included a proposal to split our current Business, Consumer Services, and Housing Agency into 2 state agencies, the California Housing and Homelessness Agency and the Business and Consumer Services Agency. The proposed California Housing and Homelessness Agency, I have a new acronym for you, CHHA, will oversee housing and homelessness solutions and safeguard civil rights. The new Business and Consumer Services Agency will be responsible for consumer affairs, licensing, and enforcement. The Department of Consumer Affairs would be among 8 entities in this new agency. As part of the process in state government on April 4th, the governor's reorganization plan was delivered to the nonpartisan Little Hoover Commission for review. The submission of the plan to the commission began an approximate 90-day formal process. The commission is conducting public hearings on April 23rd and 24th for interested parties to provide input on the proposed reorganization. After the hearings, and within 30 days of the plan being submitted to the commission will write a report that it will submit to the governor and the legislature. The commission's report will offer a recommendation to the governor and the legislature as to whether it believes the reorganization plan should go into effect. The commission sometimes offers recommendations for how the plan could be strengthened, either through administrative actions or subsequent legislation. The legislature will then have 60 days to review and consider the reorganization plan. The governor's plan becomes effective on the 61st day after it has been given to the legislature, unless either the Senate or the Assembly adopts by majority vote a resolution to reject the plan. If approved, the Business and Consumer Services Agency will be created in July 2025 with 1 year of transition and will become operative on July 1st, 2026. In addition to several virtual briefings hosted by Secretary Moss, there is detailed information available on the reorganization plan website. And I'm going to read this to you in case you're interested and like to check it out. At https://bcs.ca.gov/about/reorganization. We believe this is an extraordinary opportunity for DCA to better align with other consumer protection entities. With a dedicated consumer protection focused secretary within the governor's cabinet, this is an exciting opportunity that will only strengthen our mission, momentum, and delivery of services to California. DCA will continue to keep board and bureau leadership updated on the progress of the governor's reorganization plan. Next, I did have information that I was going to share on the hybrid telework transition, but your executive officer provided you some details on that as it impacts the board, so I'm going to omit that from my report. My last item is information regarding DCA's new compliance and equity officer. On Monday, April 14th, the DCA director announced Levi Hull as the new compliance and equity officer. DCA's compliance and equity officer is responsible for leading and coordinating department-wide quality improvement efforts to ensure consistency and regulatory compliance. This position oversees DCA's solid planning and training services, the Organizational Improvement Office, the Equal Employment Opportunity Office, and the Internal Audit Office, and serves as a liaison to the department's Diversity, Equity, and Inclusion Steering Committee. As the department's equity officer, this position is dedicated to enhancing the diversity, equity, and inclusion and accessibility policies, trainings, and activities through the department's programs. Mr. Hull brings more than 12 years of experience in leading multidisciplinary teams and driving strategic program development. With more than 9 years of experience in EEO compliance and program management, including nearly 3 years at DCA, he is an experienced EEO officer with a deep commitment to fostering inclusive, equitable, and accessible work environments. This concludes my report today. Thank you again for the opportunity to be here with you today. And at this time, I'll turn the floor back to President Kidd, and I would be happy to answer any questions.
Thank you for that great presentation. Are there any questions or comments from the board members? Hearing none, are there any public comments on WebEx?
Thank you, Mr. Board President. And at this time, all our attendees have signed out, so we have no attendees on WebEx.
All righty. Thank you.
So you're welcome.
And thank you for that director's update. We greatly appreciate that.
All right, you're welcome. Thank you.
So we're moving with lightning speed here. So we have already addressed agenda item number 10, which was the budget analyst report. So we're going to move on to agenda item number 11, report on Medical Board of California activities. Dr. Sy.
Thank you, Mr. President. Welcome to the new board members. I guess my report was so exciting, everybody signed off. The California Medical Board met on February 12th to the 14th in Fresno, California at the St. Agnes Medical Center. The Medical Board of California usually holds its quarterly meetings around the state, and for the last couple of years, we tried to include Central California in participation and inclusion in the medical board. So last year was Bakersfield, and this year was in Fresno. Some of the highlights of the meeting, one of the key things I talked about last meeting was that all of the application was digital. Now all facets of your application are digital, including your transcripts, your diploma, everything is digital now. Your licenses are digital. So unfortunately, with what happened in the wildfires in LA, the licensees are able to get a QR code from the website or download their pocket license from the website. So that alleviates a lot of the stress from trying to get a actual physical copy of your license. Secondly, one of the things that we approved was once a licensee goes into probation, he or she may petition for early termination due to the various conducts, improvements, rehabilitation. And so if a licensee chooses to appeal and apply for early termination, associated costs that goes into investigating and getting all the information was all borne by the board in the past. Now we approved fees for the licensee if they are to appeal and request early termination. They would have to borne the cost of this investigation, usually averaging about $12,000 to $15,000. That's another way for the board not to bear the burden of sort of investigation when a licensee appeals or applies for early termination. Lastly, one of the future agenda or tasks that the board is now looking into is that once a complaint is filed as a consumer, as a patient, this now goes into a black box. You submit a complaint, you don't know what the status is, it goes into the Medical Board of California. You may or may not be contacted, and once the decision is rendered, there's no reply and your case has been closed or whatnot, and it leaves the patients sort of on the edge of a cliff, not knowing what's going on with their investigation. So we have now directed the staff to evaluate a notification process so that when a complaint is filed at every stage of the process, the filing complainant is notified of where in the process that the complaint is in. Obviously, we have to, that's why we directed the board to sort of evaluate at what timeline, what part of this process should people be notified, what to notify them, and how to notify them. Is it through just an email? Is it through a call? So that's sort of on the horizon for the medical board, because I think a lot of the frustration for people filing complaints is that you as a patient, obviously consumer, filing a complaint, you have absolutely, you're not a part of the process anymore. Once your complaint is in, you feel helpless that I don't know what's going on. So a lot of patients are actively trying to seek answers on what's the status of their complaint. And so with a protocol or a process, then it would be a well-known sort of timeline when people will get notified and what information is relayed to the complainant. So that's sort of on the horizon. Thank you.
Dr. Sy, great presentation. Quick question for you. I know, and Rosanna, correct me if I'm wrong, whenever there's a complaint filed to the PA board, we act on that complaint within 10 days. Is that correct?
Yes, that is our mandate.
Yeah.
And similar with the medical.
So
Yeah, so you're once you've, and of course, the Medical Board of California even started a new complaint liaison department, because I think a lot of the frustration is people don't know what's going on. And when you don't know what's going on, you feel frustrated. And I think a lot of response from the public was what's going on. And when you don't have information, it sort of breeds the sense of distrust and what's going on, what are you guys doing? And so we're trying to make that process more apparent. Of course, once you submit the complaint, there's always an email response that says your complaint has been received and there's an investigation. But after that, people don't know. And a lot of the public and the patients are sort of actively going, what's going on? What's the process? So the complaint liaison department are now, and it's fully staffed now with people trying to reach the complainants about, okay, what's going on? Is there anything? Because I think once people feel like they're a part of the process, then everything becomes more transparent.
Thank you, Dr. Sy.
Thank you.
Any other questions or comments for Dr. Sy? Debbie, do you have a question? Yes, absolutely. So thank you for that. I guess one
I had
thing
a
that we
quick
needed to-
question, if I
Yeah.
may. Sorry, just to help me understand historical component here. Prior to that last meeting, investigatory costs associated from the medical board were not passed on to the licensees. That was the change that was made, or?
Yes. So in the past, when a licensee is placed on probation, they complete their term of probation, they go off probation. But for various reasons, if your probation is 5 years, at the end of year 4, at year 4, you have complied with, the medical record keeping course, the ethics course. You can petition for early termination because you've satisfied, I've been in compliance for over 70%, 80% of the time. So they can file for early termination of their probation. With that said, when you file for early termination, investigation has to occur, right? Everything that's going into reviewing your record now is extra additional cost borne by the staff. And so sometimes it's granted, sometimes it's not. Goes to an ALJ, they determine. So of course, when you go to an ALJ, there's the attorney general's fees, attorney's fees. So the board was eating that cost since then. And of course, with budget issues, with fees increases, we sort of said, well, share this burden. If you're going to petition, we're happy to entertain your petition, but you have to sort of borne some of the cost.
And Dr. Sy, I think that's a great for bottom line expectations, right?
Yeah.
Yes.
I'm sorry. Michael Kenotes, legal counsel. Just to add to that, it used to be unique that the medical board had no requirement in the law for cost recovery. That changed via a bill, I think 3 or 4 years.
Yeah.
3 or 4 years ago. Most, if not all other boards have that component. And it is for both, it can be for a petition, but in initial cases,
Yes.
the investigation costs can be very high. So that's what gets passed on.
So you kind of answered my question, Michael. Thank you. So there was no pass on of costs previously and now there is, or is it discretionary?
There is. I mean, it's always discretionary in terms of an ALJ reviews those. But the medical board uniquely in the past had a statute forbidding cost recovery. So it was basically all paid by licensing fees.
Can't imagine who lobbied for that. Okay. All right, but that's been changed now so that there is a pass through. Okay. All right. Thank you.
And just before we take a bio break, are there any public comments on WebEx regarding Dr. Sai's report?
Thank you, Mr. Board President, for asking, and we still have no attendees.
All right. And with that, we'll be in recess for 15 minutes. Thank you so much. Thank you, Dr. Sai. We're back from recess. We are now on agenda item number 12, a discussion and possible action to reconsider previously approved text and to consider initiation of a rulemaking to amend Title 16 California Code of Regulations, Section 1399.515 regarding retired status updates and returned fingerprinting requirement. Christy Shields and Ms. Dillon.
Good morning, Jasmine Dillon, Legislative and Regulatory Specialist.
Christy Shields, Regulations Counsel for the Board.
So just to give you some background on this regulation package, AB 2461 was amended Penal Code Section 11105.2 subsection D, so that the board is required to notify the Department of Justice when the licensee can no longer renew their license. The Department of Justice then stops reporting subsequent state or federal arrests or dispositions to the board. Title 16 California Code of Regulations, Section 1399.515 currently allows individuals with a retired status license to reactivate their license if they complete certain requirements, but fingerprinting to allow receipt of criminal offender record information from the DOJ's database is not included. At its August 9th, 2021 board meeting, the board discussed the risks of the board reactivating the license of a retired physician assistant who has gotten a state or federal arrest or disposition since retiring their license and making amendments to Section 1399.515 to require retired status licensees who seek to reactivate their license to provide fingerprints to the DOJ so the board may conduct criminal history background checks and other non-substantive changes. Changes originally suggested to the proposed language at the August 9th, 2021 meeting are shown in Attachment 3. Since that time, Current Regulations Council has suggested further changes. The proposed changes to the language in the retired status updates and return fingerprint requirement rulemaking text at Section 1399.515 are shown in Attachment 1, and those changes include updating the date of the form incorporated by reference to April 2025 to reflect changes made to that form, adding language to include a limitation as to time when an individual can restore their license from retired status to active status, which is within 5 years of being issued a retired license. The time frame is consistent with the 5-year cancellation provision in the Business and Professions Code Section 3526 for licensees who fail to renew their PA license within 5 years after their license expires. Section 3526 prohibits the board from renewing or reinstating such a license. This requirement ensures currency of knowledge for those who re-enter practice after being retired for years. Changes also include adding subparagraphs to make the regulation easier to read and striking obsolete grandfathering provisions that allowed Licensees who had canceled to be eligible for the retired status license without paying any fees if they applied within 1 year from the effective date of this regulation, originally effective April 1, 2019. Since that eligibility window passed April 1st, 2020, this language should be repealed as no longer necessary. Changes would also include retaining the fingerprinting requirement, but clarifying that the board will only request fingerprints if they do not exist in the DOJ's database, as well as specifying that if a licensee who has been in retired status for more than 5 years seeks an active license, the individual may apply for a new license pursuant to California Code of Regulations, Section 1399.506. And the proposed revisions to the application for retired status are shown in Attachment 2. Changes to the application are shown in underline, strikeout, and highlight. These changes include removing the old board logo and letterhead and replacing it with a new letterhead and board logo to provide uniformity with the board's forms. This also includes removing the old requirement regarding waiver of fees for those applying before April 1st, 2020, and as it is not relevant for applicants applying now, as well as non-substantive changes to add new paragraph lettering for better readability, and removing gendered language and making grammatical changes, as well as updating the declaration to ensure that the applicant attests to providing correct information and is the individual completing and signing the application. And finally, it would update the board's suite number and website for accuracy. Similar changes have been implemented by other healing arts boards in the department. Most recently, the Physical Therapy Board adopted changes in 2023, similar to the ones outlined in the proposal at Title 16 California Code of Regulations, Section 1398.18. And staff would recommend that the board review and discuss the provided materials and language that has changed since the last board vote. The board may wish to determine whether to approve the revised regulatory language and initiate the rulemaking process using the revised regulatory language in attachments 1 and 2, which includes changes made to the application for retired status form.
I know we have some new members, so I just want to give a little bit further background so you can kind of understand what you're voting on. It's a little complicated. So regulations in the department for the boards in the department and bureaus in the department have to go through a review process. And it starts with the meeting we're having today where you approve text, then it moves to the director of the Department of Consumer Affairs who can review or disapprove the proposal. Hopefully she'll approve it and moves on to the Business Consumer Services and Housing Agency, soon to be retitled, for their review. There's attorneys at that agency that look at it and ask questions and, may have issues with some of the text, but hopefully they would approve it. Once they've approved it and signed off on the Form 399, which is we're required to do for each rulemaking, that analyzes fiscal and economic impacts to businesses and the regulated community. And they sign it, then it would go to the Office of Administrative Law. That's the agency that reviews regulations for all state agencies in the state. So it's a very complicated process, but we're here to make sure that your policies are implemented. My job is to defend whatever you approve at these meetings with the various agencies, control agencies is what we call them, as they make their way through the process. If there are issues, I will bring it back to you after this meeting and let you know, and then we can decide what we want to do from there. If you look at attachment 1 in the meeting materials, that is the actual policy changes we're asking you to approve. And when you look at a document like this, you'll notice there are things that are underlined and struck through and things that are not. When text is not underlined, it represents existing text that we don't propose to change with this action. If we ask you to make changes or we're suggesting changes, then it would be in strikeout or underline. So things that we're proposing to repeal would be struck through and things that we're proposing to underline or add would be underlined. So really quickly, back in 2019, the board did not have a retired status. And so people would just not pay their renewal fees and cancel. And then they would look themselves up on the internet and say, I'm canceled. I've been canceled. And so they went and complained to the legislature and the board was sympathetic to that. And so we've implemented a retired status program where people can apply for that status if they don't want to practice any longer and then have an opportunity to come back into practice. One of the things we were looking at when we were looking at updating the regulation was the fact that back in 2019, when you board originally approved and adopted this regulation, there was no limitation on when they could come back and restore their license. So potentially you could have somebody that had been retired for 20 years, come back and say, I want to restore my license, do some continuing education to pay a few fees and come back into practice, which we don't recommend because your statutes say that you're not allowed to reinstate a license that's that has been out of practice for more than 5 years. So if you've been canceled for 5 years, you're not allowed to just restore your old license. You'd have to come back, reapply, take exams, prove you're still, competent in the field, and go through the initial licensure process. So that's the current process for people that cancel, but you don't have a similar cap on returning. A revolving door is what we have going on right now. There's no cap on that revolving door where people can come back. So one of the things we're asking you to do is put the same limitation in place that you put in for people that cancel, which is after 5 years, you cannot restore your retired license to active status. And then we have a few other cleanup changes, one of which is people who previously could cancel. We gave them 1 year to flip to retired status without paying a fee, but that 1 year window expired back in 2020. So we're deleting that language. Do you have any questions about the text that you have in front of you?
No question specifically about the text, but that does bring up a question after 5 years, right? Where you want to restore your license, but you can't do it because it wasn't within that 5-year window.
Right.
Would the board then require them to retake the PANTS?
Yeah, everything all over again.
Okay.
Yeah. That's the way the other boards in the department have been doing it. And we were one of the first boards to actually adopt a retired status license. And when I worked on it, I wasn't thinking about the revolving door and nobody caught it. And so as I've been working with other boards in the department and they've been adding that stop, and Michael, I believe, was counsel for physical therapy when we worked on the regulations for them, they've added the cap in there. And so we put in that 5-year, consistent with what you have for canceled licenses. Requirements is to make sure they have currency of knowledge and to protect the public.
Yeah, I'm in agreement with the proposed text. I don't have any specific comments or questions. Thank you both for your presentation. I'll open it up to the board to see if there's any specific questions or comments. Okay. Hearing none, are there any comments on WebEx?
Thank you, Mr. Board President, for asking, and we still have no attendees, public attendees.
So the motion that we're requesting the board pass is on the 3rd page of the memo. I apologize for the length of the motion. Again, that Office of Administrative Law that does the approving of these regulatory packages wants to make sure every single delegation is clearly outlined. And so the motion's gotten longer and longer every year I've been here practically. So anyway, that motion, if you want to just say moved as set forth in the meeting materials, Michael, are you okay with that?
Does anyone, Mike, could she read the motion?
Do you want me to read the motion?
I mean, it's in the materials. We can just move the motion, or that's the preference of the president.
Let's do it.
Mr. Chair.
Yeah.
Yeah, I moved the staff suggested motion, and I'm not going to read it. Thank you for putting it in there.
Okay.
Is there a second?
But just to clarify, it is to rescind the board's prior.
Yeah, the text
cetera.
in attachment 2 is what you approved back in 2021 when I was at your council. But and so I looked at it this time and I said, there's that issue that we didn't address in the prior text. And so I just added a few more updates in there. And I thought that, you probably would want to go with attachment 1, but you'd want to see what you had approved previously. So the motion would rescind attachment 2 and in place put in attachment 1 text to move forward through the process.
And the rest of the language.
Correct. Yes.
I'm sorry.
I heard a motion, but not a second.
Yes, that's what I was getting ready to ask. Second. Okay. Thank you. Should I ask if there's any public comment on WebEx? I don't think there's anyone on WebEx. No. So then the motion is adopted.
Oh, you got to vote.
Oh, I'm sorry. We need a vote. A roll call, please.
Juan Armenta,
Aye.
Eric Bergensen, Philip DeVizio,
Aye.
Diego Insunza,
Aye.
Vasco Diankit,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash,
Aye.
Deborah Snow.
Aye.
The motion stands adopted. Thank you.
Thank you.
Thank you both for your presentation. So Ms. Dillon, I think you'll be staying with us because you're going to be doing the regulations update on pending regulatory packages.
Yes. So the first package is SB 697, license renewal and continuing medical education required. This package is currently on hold pending legislation in 2025 as the board is seeking amendments to Business and Professions Code Section 3523 to address apparent authority issues with providing the renewal application online through Breeze. And once we get that changed, then we will resume working on this package. And the next package is application exam scores and addresses and record keeping. This package was adopted, the board adopted the proposed revised regulatory language to initiate the rulemaking process at the November 8th, 2024 board meeting. And the package is currently pending review with Department of Consumer Affairs, Legal Office, and Budget Office. The next package is the one that was just discussed in Agenda Item 12, retired status updates and return fingerprint requirement. And the board was asked to adopt the proposed revised regulatory language to initiate the rulemaking process. The next package titled Implement Uniform Standards Related to Substance Abusing Licensees and Update of Disciplinary Guidelines. Staff is currently working on proposed language for board approval this calendar year. And finally, the initial license fee increase package. At the November 8th, 2024 board meeting, the board voted to adopt the proposed regulatory text to initiate the rulemaking process. Agency approved this package on March 5th, 2025, and the notice was filed with the Office of Administrative Law for publication on March 21st, 2025 to initiate the 45-day public comment period, which will end on May 5th, 2025. And that concludes my update.
Thank you, Ms. Dillon. Are there any comments or questions from the board?
Yeah, on the 1399.550 item 5, the fee increase. I see the public comment period closes a month, or not even a month from now, a few weeks from now. Have there been any comments so far?
No, none have been received so far.
Okay, thanks.
All right. Any comments from any other board members? No? Okay. I'm going to ask, are there any public comments on WebEx?
I appreciate you asking, and there are no comments from WebEx. No one is logged in.
Okay. So should I move forward, continue to say that since we don't have anyone logged in?
I think we should, because we could have a member of the public log in during the intervening item. So I think
Okay.
we should check.
Okay, thank you. Thank you, Ms. Dillon, for that report.
Thank
We
you.
appreciate that. Moving on to agenda item number 14, the Education Workforce Development Advisory Committee, which has been renamed Physician Assistant Training, Accreditation, and Workforce Development Committee. So there are currently 312 nationally accredited physician assistant programs in the United States. Of those, 20 are located in California. I'm pleased to report that none of the California PA programs are on probation. Western University of Health Sciences, which was on probation, has now been off probation this or last year, and so we're pretty excited about that. Presently, there are 6 provisionally accredited programs, and many of you know provisional accreditation is a 5-year process, and there are 4 developing programs within the state. Geographically, California's PA programs are distributed as follows. 15 are in Southern California, 4 are in the Bay Area, and 1 is in Central Valley. As a reminder, 2 PA programs in California have closed in recent years: California State University, Monterey Bay, and more recently, the University of La Verne. Several of those students that were in the La Verne program have been absorbed by Loma Linda University PA program in Loma Linda, California. The current annual enrollment capacity across the 20 California PA programs is nearly 1,000 students entering the workforce annually, with an average of 48 students per cohort. With planned cohort expansions, the estimated total annual capacity is projected to increase to nearly 1,100 enrollees. As a reminder, there are 18, well, I guess now there's 19,000 licensees in the state of California, the second largest population of PAs in the country. And that will conclude my report. Are there any questions or comments from the board?
I have a comment. It's interesting that we don't have a institution to cover PAs, literally the deficit in the Central Coast that I'm seeing. Is there any thought from the board or any discussions that has happened in the past about institutions that may be considering?
Yeah, so that's a great question. There's one program in A.T. Steele University Central where there is, and that's a provisionally accredited program right now. As mentioned earlier, Cal State University, Monterey Bay recently closed its doors. There has been no discussion on reactivating that program. They had some accreditation issues and those students were absorbed by other programs. So that is an area of great need. And that was actually asked by one of the legislature during the Joint Sunset Review Committee regarding that. So certainly I think hopefully will be some future development of programs in that area. But as it stands today, we don't know exactly how they're going to fill that healthcare gap. Any additional comments or questions from board members? All right, are there any comments on WebEx?
Thank you for asking. We still have no attendees.
All right, so now we're going to move on to agenda item number 15, report by legislative specialist, Ms. Dillon.
All right, so the legislative update, I just want to point out that the page prior to the memo for the new board members is, it includes legislative positions that the board may take on these bills. And there's a little description on what taking that position means for that bill. And any discussions that are had or any amendments that are discussed that you would like for me to take back to the legislative staff, we can discuss anything with them and see what they're able to do, and we can open that discussion on those bills. So I just wanted to point that out because I know sometimes it can be a little confusing on the positions that the board takes, but there is a little description there to help guide you. So let's see, agenda item 15A, excuse me, is Assembly Bill 447, Emergency Room Patient Prescriptions. This bill was introduced on February 6th, 2025, and is located in the Assembly Health Committee. Current law authorizes a prescriber to dispense a dangerous drug, including a controlled substance, to an emergency room patient if specified requirements are met, including that the dangerous drug is acquired by the hospital pharmacy. This bill, notwithstanding any other law, authorizes a prescriber to dispense an unused portion of a dangerous drug acquired by the hospital pharmacy to an emergency room patient upon discharge under certain conditions, including that the dangerous drug is not a controlled substance and that dispensing the unused portion of the dangerous drug is required to continue treatment of the patient. And just to provide some background on this bill, the medications that they're discussing in this bill or referring to would include eye drops, inhalers, and liquid antibiotics, just to name a few. And under existing law, the remaining doses cannot be sent home with the patient or used for other patients, leading to unnecessary medical waste, which is the reasoning for this bill. And so this bill would allow for hospitals to do that.
So thank you, Ms. Dillon. I'll just, before I open it up to the board, I'm in support of this bill. I think it's, as you mentioned, it allows for redistribution of those medications back to the patient. I would also just like to let the board members know that the California chapter of American College of Emergency Physicians is also in support of this bill, as well as the California Medical Association. I did not see any opposition towards this bill when I reviewed it. Is that correct?
I believe that's correct.
Okay. I'll open up to board members for comments and questions. Should we take a support stance on this? Does anyone disagree with that?
No, I think it's appropriate, at least in my opinion, to support this.
Okay. Good thing is we have some emergency room folks on the board, so I'll look to them for guidance on that. All right, so it looks like we're going to take a support position on this bill. Do we need motion? So would someone like to make a motion?
I make a motion that we take a supportive position on Assembly Bill AB 447.
Thank you. As a second, okay. Ms. Burke, could you take roll, please?
Yes.
Oh, public comment on WebEx?
Thank you for asking, and we have no attendees.
Ms. Earl, will you please call the vote?
Juan Armenta,
Aye.
Eric Bergeson,
Aye.
Philip DeVizio,
Aye.
Diego Insunza,
Aye.
Vasco Diankit,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash,
Aye.
Deborah Snow.
Aye.
Motion stands. We'll take a position. Thank you.
All right, moving on to AB 479, Criminal Procedure Vacatur Relief. This bill was introduced on February 10th, 2025, and is located in the Assembly Public Safety Committee. Current law allows a person who is arrested or convicted of a nonviolent offense while they were a victim of intimate partner violence or sexual violence to petition the court under penalty of perjury for vacatur relief. Current law requires, in order to receive that relief, the petitioner established by clear and convincing evidence that the arrest or conviction was the direct result of being a victim of intimate partner violence or sexual violence that demonstrates the petitioner lacked the requisite intent. Current law authorizes the court to vacate the conviction if it makes specific findings. This bill would require the court, before it may vacate the conviction, to make findings regarding the impact on public health, safety, and welfare if the petitioner holds a license as defined, and the offense is substantially related to the qualifications, functions, or duties of a licensee. And this would, the bill would help notify the appropriate licensing board, allowing the board to testify and participate in that process. And just a little background on this bill as well. In 2024, there was a case regarding a licensee of the Board of Registered Nursing, and the particular individual was convicted of child pornography and was found to have a substantial amount of materials in their possession. Before the licensee has filed a petition to vacate their charges, the Board of Registered Nursing began the process to revoke their license. And without any notifications, the licensee filed the petition, was ultimately granted, and in resulting in the Board of Registered Nursing having stop the process to revoke the individual's license. And that individual was able to pursue their career. So that was just a little bit of background on why this bill was brought forward.
So I'll just say I'm in support of this bill. I think it enhances public safety by ensuring the licensing boards are notified with individuals with serious convictions, petition to clear their record. So I think it's a good opportunity to make sure there's checks and balances that protect the public. However, I'm going to open it up to board members to get their input.
I'm wondering how this coincides with the other law, Michael, that prohibits us from, the clean slate law that prohibits us from looking at prior convictions and everything else. Do we have any analysis of that, or we're going to leave that up to the legislature when they get to it?
Well, that's more of a matter for initial applications of licenses.
I see. Okay. Well, isn't there a conflict though, even in that scenario?
Well, I mean, this is a very specific provision regarding individuals who were victims and had convictions during so it's a very specific procedure here. I don't really see an impact there.
Okay.
Yeah.
And just a quick question, in terms of expungement, does this have any impact on that? Michael, your thoughts?
Well, I mean, it's a separate, expungement is a separate procedure.
Right.
Here, the conviction would actually be vacated.
Okay.
So expungement is sort of, you've gone through your process, you've served your probation, you've paid all your costs, you've done your time, and we're going to now consider wiping that off your record.
Okay. Thank you.
So there's different procedures for that.
Okay.
Just had a question. I haven't read the bill in full, so I understand it requires the court to make a finding when it involves the licensee. But is there something in the bill that provides a mechanism for the licensing agency to be notified?
It just says that the healing, like the appropriate board will be notified. I'm sure that there will be more details coming forward on that. Because this bill was just introduced as well, so there will be more amendments, and I can get clarity on that too from the legislative staff as well. But I believe the board has the option to, attend the hearings and also testify. It's not a requirement, but I can get more clarification on that process for you.
Yeah,
and get back to
assuming
you.
the court will notify the agency.
That's a great question. Here, in the author's comments,
Mhm.
it says that it enhances public safety by ensuring licensing boards are notified, but it doesn't say what mechanism, to your point, that notification would occur.
I would think that would happen through the clerk's office, through the administrative arm of the courts.
So should we, as the board, take a position of support?
Well, I don't, aren't we going to ask for some more information on that? I thought that's what I was hearing, that you were going to check with.
Yeah, I can definitely get more information on that process.
Yeah.
Yeah.
Yeah. So
We
maybe
don't, we don't have to take a position today.
Yeah.
Right.
Yeah, and then get more information, maybe come back.
Yep.
Okay.
I mean, I agree with Michael that this is a pretty narrow, and it's not likely going to come up very often, I wouldn't think.
Could we take a watch position?
Yeah,
Is that
watch.
what-
Yeah.
okay.
So do we
Until
need-
we have more information.
You do. Okay. So the board would take a watch position on that.
Perfect.
All right, thank you, Ms. Dillon.
All right. So moving on to AB 489, Healthcare Professions, Deceptive Terms or Letters, Artificial Intelligence. This bill was introduced on February 10th, 2025, and is located in the Assembly Privacy and Consumer Protection Committee. Current laws, including among others, the Medical Practice Act and the Dental Practice Act, make it a crime for a person who is not licensed as a specified healthcare professional to use certain words, letters, or phrases, or any other terms that imply that they are authorized to practice that profession. Current law requires, with certain exemptions, a health facility, clinic, a physician's office, or office of a group practice that uses generative artificial intelligence as defined to generate written or verbal patient communications pertaining to patient clinical information as defined, to ensure that those communications include both, one, a disclaimer that indicates to the patient that a communication was generated by generative artificial intelligence as specified, and two, clear instructions describing how a patient may contact a human health care provider or employee or other appropriate person. So this bill would make provisions of law that prohibit the use of specified terms, letters, or phrases to falsely indicate or imply possession of a license or certificate to practice a healthcare profession, enforceable against an entity who develops or deploys artificial intelligence or generative artificial intelligence technology that uses one or more of those terms, letters, or phrases in its advertising or functionality. This bill would prohibit the use by AI or Gen AI technology of certain terms, letters, or phrases that indicate or imply that the advice or care advice, care, reports, or assessments being provided through AI or Gen AI is being provided by a natural person with the appropriated healthcare license or certificate.
Thank you so much. Any comments regarding AB 489? I mean, I think, at least from my perspective, it sounds like a pretty good opportunity to ensure that we have checks and balances when it comes to artificial intelligence. And seems like the bill puts in public protection through a mechanism of ensuring that folks that are receiving information, that it's not being somehow misrepresented as a kind of a live person or using specific initials that would indicate it's a licensee.
Right. And we've seen chat boxes. I've seen one before. The chat box would just, identify itself as a practicing, physician, for example, and it misleads the user into believing that you're speaking with a licensed professional. And so,
Vicariously through the use of AI.
yeah,
Yeah.
But where, help me, where have you seen that?
I've seen it on a colleague's computer when this bill was being discussed at a meeting.
Oh, so they showed you the.
They showed us the
the
chat box.
exemplar.
And
So
yeah.
it comes across as its actual advice from some type of
Healthcare
practitioner.
Right. In this specific one, they didn't state a name or license number, but it did imply that they were licensed by the state. So that could be very misleading.
And was the origin of that domestic or foreign?
I'm not sure about that.
That's a pretty important question because this law would only, do so much. What page is the text on of it? 96. Okay. So where is it at in the process right now?
It is in the Assembly Privacy and Consumer Protection Committee, so they're reviewing it. It's still in the early stages though, so this was introduced on February 10th, so there's a lot of room for input, and we can suggest amendments as well, anything that the board would wish to relay back to staff.
My fear is Dion, is that this is such an evolving and complex area that attempting to legislate at this point without even understanding the contours of what we're trying to protect against is a little dangerous. I would propose that we take a wait and see on this and see what it's going to do, because I can imagine artificial intelligence as it grows, something that everybody in this board might find, hey, that might be useful for us to use. And I don't know that we should box ourselves in at this very early stage. And again, I say that with some reticence too, because this is a dangerous and evolving field. I don't think we have the expertise yet to take a sound position on it. I think the doctor side has something.
Yeah, thank you. I think from the medical board's perspective is that if you're doing any sort of emailing chat, you should know it's a computer.
Right.
You should, anytime you chat with somebody, you assume that the other end is a person typing that response, but now AI is taking over. So I think the medical board's position in looking at this is, as long as you identify, I am a computer, so that the consumer / patient understands this is coming from an artificial intelligence, that's fine, as long as you disclaim it. You can't say, Dr. Robot, this is Dr. Robot, and I'm giving you how to cure your ear infection, when the person thinks, oh, it just means that his last name is Robot, And so I think from the medical board perspective is that as long as you identify that if you're a robot, you can't call yourself a doctor, then at least you know that you're talking to a robot.
Yeah, and just to dovetail on that, we are using artificial intelligence in healthcare. We're using it for predictive analytics, for responding to patient messages, in some cases for medical decision-making. And so to Dr. Sai's point, I think being able to really know who you're, is it the artificial intelligence, algorithm you're talking to, or is it a licensee that's typing something through that's coming out? So I do think there is some merit to this bill. And I do think as a board, we should take some position on it. Now, again, it's probably going to come back, right? I mean, I think it's going to come back with amendments and other things that we're going to have to take a look at it. But certainly it seems, in my viewpoint, a focus on public protection, given the wide use of AI and how patients are actually looking to kind of self-diagnose through AI. I think is somewhat problematic. So I think that is some concerns, even by the California legislature during our joint sunset review, where concerns around artificial intelligence was also articulated. So I do think maybe we should we can certainly take a watch and see if everyone is okay with that, or we can take a support on the bill, and then it could come back and we could take another look at it. I think either or is fine.
Well, here's the problem. I see. I get the idea that Dr. Sai put it perfectly, right?
Mm-hmm.
If you're being told it is a real flesh and blood doctor, terrific, great. Okay. The problem is this bill puts the onus on us. Right? It says the appropriate healthcare professional licensing board may pursue an injunction or restraining order to enforce the provisions of this chapter. So even the legislature is saying, yeah, we're gonna kind of outlaw, but hey, it's up to you guys to deal with it. So that's why I don't think this bill is mature enough yet. I think it needs some tweaking, and I don't know. That's the part that really makes me uncomfortable, just the procedure of it. Yeah, why should this come out of our budget?
Yeah.
If it's a statewide problem
Yeah.
for all boards, why should this be our problem? I think the legislature should be funding this.
I actually would agree with Mr. Armento on that. So is there something we could convey back to the author of the bill specifically regarding the actual enforcement and cost of, trying to operationalize this if this becomes an issue?
Yeah, we can definitely convey that we can afford to enforce this bill. We haven't received any complaints that I know of regarding AI and its use against our licensees, but I think that going forward, there might be some issues with our budget, like you said, and that's something that we can definitely convey back to the author's office in a letter.
So now I guess we're back to the circular question here. Do we take a position on the bill now, or do we do a watch? Wait, I just tell you, I'm in favor of taking a position on the bill. I understand there's some kinks that need to be worked out, and that can certainly will get worked out along the way. This is not the final draft, or again, we can take a watch and see approach. I'm okay with either or. Anybody want to make a motion?
Didn't want to make a motion, but I do have a question.
Sure.
This is, feathered in for the rookie over here. Does this bill allow an organization to, when they bring on board a patient, they can sign a document that says, some of our follow-up would be provided by AI, and that would cover them? Or is this something with each occurrence and each interaction that needs to be delineated? I'm looking at this and I don't see that it's clear. Can we ask for more clarity on that?
Yep.
Yeah, we can definitely ask for more clarity on that. Yep.
So based on that, Mr. Deviser, maybe we should take a watch and see approach.
Yeah, we can watch and see and then ask Ms. Dillon to make inquiries, correct?
Yeah.
It's entirely appropriate. Yeah, I think, 500 words to address a problem that
is this big.
I don't think that's,
Yeah.
I think it's a problem.
Yeah. So we look forward to seeing a follow-up
Okay.
on that.
Perfect.
Thank you.
Thank you. All right, so moving on to item number D.
Sorry, do we have to make a motion to do a watch?
No,
or
no.
Okay, thank you.
Moving on to item number D, AB 667, Professions and Vocations License Exams Interpreters. This bill was introduced on February 14th, 2025, and is located in the Assembly Health Committee. And this bill would, beginning on July 1st, 2026, require certain boards under the jurisdiction of the Department of Consumer Affairs to permit an applicant who cannot read, speak, or write in English to use an interpreter to interpret the English written and oral portions of the license exam if the applicant meets all of the requirements for licensure. This bill would require an interpreter to satisfy specified requirements, including not having the license for which the applicant is taking the exam, and would prohibit the assistance of an interpreter under certain circumstances, including when the English language proficiency is required for the license.
So just to make sure, I may have missed that, but does this apply to us because we don't require or administer state licensing exams?
I don't think it would apply to us because,
Right.
we don't
Yeah, we have a
don't
national exam.
regulate that.
Exactly.
In a sense.
So for us, this doesn't really impact the PA board.
Correct.
Thank you.
Michael Kanotes, let me just sort of jump in there, because the concern could be that if this bill is enacted, how do we comply with that? Because what it's saying, because although the national licensing exams of all the boards are established and administered by another entity, they are all creatures of state law in that the examination is required, and then we sort of contract out and make it the requirement through our regulations that it actually be the exam that's offered by the national organization. So what I'm saying is I'm not quite sure how they would comply with this because then I'm not sure how the board would require the national organization.
Yeah, and I'm not sure. Yeah, that's a great question. Yeah, Michael, and I don't really have an answer for that because all PAs are nationally certified. We don't administer state licensing exams. We really have no control of what actually goes into the blueprint, the NCCPA blueprint, in which PAs are tested on through the physician assistant, the national certification exam, and the recertification exam that we take every 10 years. I think Christy has.
So just to restate what Mr. Knutz was saying, the current statutes allow you to elect to administer your own exam or to select another examination opportunity vendor. And currently in regulation, you've specified the national exam. So the argument would be that you've exercised your discretion to select that exam. And so that's your exam. And so there's nothing in the bill that delineates and distinguishes between board administered examinations and those that are administered through a third party. So that's the concern he's raising. And since your regulations set forth the national exam, again, there may need to be some exemption specified in the legislation for those examinations that are national examinations or something to that effect. I don't know, because otherwise you will have to address this in regulation somehow. And I don't know how you'd work with the national. I know how difficult it is to work with the national examination vendor. So how we would work with complying with that law and how we would reflect that in regulations, and that they may have an option for people that have ESL issues, but I don't know what those are and whether they would comply with our statute. So we'd be in a kind of a difficult situation.
Yeah, that's a
regulatorily.
Yeah, that's a slippery slope, right?
Right.
Because most institutions require national accreditation. Most third-party payers for reimbursement of, PA services require national accreditation. So anything we do here could potentially impact that, right? And plus other downstream effects. And so I'm a little bit concerned by that.
Right. So
because we essentially defer to the national accreditor for that. We have not done anything at the state level regarding certifying, PAs, and there's no guarantee that no other state would even recognize California's certification process, which it could limit the mobility of PAs to move between states. So I'm a little bit concerned about the whole process. And I think at least at this stage, I'm at an oppose position right now because there's just not a lot of clarity around this bill. And
or
to your
oppose
point,
unless amended.
Exactly. Opposed to less amended, and we'd have to have some of those exemptions you articulated because
Right.
there's not-
Otherwise, we'd have to regulatorily try to map out how we would be complying with
Correct.
that requirement, and I'm not sure how we would.
I think it would actually be a pretty
Next to impossible.
to do. So I just
So I think, so can I make a motion then to oppose unless amended to exclude boards that use a national testing agency or a third-party vendor, something like that?
I like that motion. Do we have a second?
I second it.
Okay. And I guess now, do we need to do public comment right here?
Yes.
Okay. Is there any public comment on the floor or on WebEx?
Thank you for asking. This is the moderator, and we still have no attendees.
Ms. Her, will you please call roll?
Yes. Juan Armenta.
Aye.
Eric Bergenson.
Aye.
Philip DeVizio.
Aye.
Diego Nzunza.
Aye.
Vasco Diankit.
Aye.
Edwin Perez.
Aye.
Bhavna Prakash.
Aye.
Deborah Snow.
Aye.
Very robust discussion on that. Thank you, everyone.
All right, moving on to item number E, AB 742, Department of Consumer Affairs, licensing applicants who are descendants of slaves. This bill was introduced on February 18th, 2025, and is located in the Assembly Judiciary Committee. This bill would require DCA boards to prioritize applicants seeking licensure who are descendants of American slaves once a process to certify descendants of American slaves is established. The bill would make those provisions operative when the certification process is established and would repeal those provisions 4 years from the date on which the provisions became operative or on January 1st, 2032, whichever is earlier. The bill would make these provisions operative only if Senate Bill 518 of the 2025-26 regular session is enacted, establishing the Bureau for Descendants of American Slavery, which would create a division to establish a process to certify descendants of American slaves.
So I have a quick comment. So this is reminiscent of AB 2862, which, if I'm not mistaken, actually died in the Senate Committee on Business Professions and Economic Development.
Correct.
And for those, it was, I think 2862 was in 2024. It would have required state licensing boards under the DCA to prioritize African-American applicants seeking licensees, especially applicants who are descendants from a person enslaved in the United States.
Correct.
So I think at that time we were at an opposed position because we already process applications within a 30-day period. So there's really no bottleneck that we anticipate for any licensee.
Right, that was correct.
Okay.
And if I could comment, this reminded me of the give priority to victims of the Armenian genocide.
Yeah, yeah.
You know, I understand that these legislators put these vanity bills up there for us, but we don't need them. We don't need to prioritize anybody given our speed and efficiency. And I don't think we should be dipping our foot into this type of legislation that prioritizes one ethnicity or victim over another, given that we don't have any constraints practically on processing.
So we will unless the board members disagree, I think we want to maintain an opposed position to this bill.
I move to oppose.
Yep. And I think so do we need to?
So we had a motion to
I'll second.
Oppose?
We need a second.
Second motion there, okay. Is there any public comment on WebEx?
Thank you for asking, and we still have no attendees.
Okay, Ms. Sir, will you please call roll?
Can I ask who motioned?
I did.
Okay, and second?
Diego.
Thank you. Okay, Juan Armenta,
Aye.
Eric Bergensen,
Aye.
Philip DeVizio,
Aye.
Diego Insunza.
Aye.
Vasco Diankit,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash,
Aye.
Deborah Snow.
Aye.
Motion stands. Approved. Thank you.
All right, moving on to item number F, AB 1501, physician assistants and podiatrists. This bill was introduced on February 24th, 2025, and is located in the Assembly Business and Professions Committee. The Medical Practice Act establishes in the Department of Consumer Affairs the Podiatric Medical Board of California to license and regulate podiatrists. The Physician Assistant Practice Act establishes in the Department of Consumer Affairs the Physician Assistant Board to license and regulate physician assistants. Current law repeals the provisions establishing those boards on January 1, 2026, and specifies the repeal of those provisions as renders those boards subject to review by the appropriate policy committees of the legislature. This bill would express the intent of the legislature to reevaluate the Podiatric Medical Board and the Physician Assistant Board through the joint legislative sunset review oversight process, and to subsequently include in this measure recommendations produced through that process. So currently, this bill does not include anything for the Physician Assistant Board. We're still awaiting on the amendments for that. And once we do hear back from the legislature on those amendments, we will bring those to the board for discussion.
So this is our sunset bill.
This is our sunset bill.
Right, so it's our sunset bill, and there will be some provisions. Currently, I think there's only podiatry stuff in there now. There's nothing related to PA. So
Correct.
I think it's better to have a watch, wait approach until we see what the legislature puts in the bill.
Perfect.
Does anyone disagree with that?
All right, moving on to Senate Bill 470, Bagley-Keene Open Meeting Act teleconferencing. This bill was introduced on February 19th, 2025, and is located in the Senate Committee on Appropriations. Existing law, the Bagley-Keene Open Meeting Act, requires with specified exceptions that all meetings of a state body may be open and public and all persons be permitted to attend any meeting of a state body. The act authorizes meetings through teleconference subject to specified requirements, including, among others, that the state body post agendas at all teleconference locations, that each teleconference location be identified in the notice, and the agenda of the meeting or proceeding, that each teleconference location be accessible to the public, that the agenda provide an opportunity for members of the public to address the state body directly at each teleconference location, and that at least one member of the state body be physically present at the location specified in the notice of the meeting. The act repeals those provisions on January 1st, 2026, and this bill would instead repeal these provisions on January 1st, 2030 to maintain important disability and public access to state board and commission meetings.
Thank you so much. So I would love to get Mike's opinion on this. This seems to provide more flexibility to boards in supporting teleconference or meetings by teleconference. And so, Mike, I'd love to get your thoughts between what we previously had versus what this new bill is suggesting. There has been some concerns about the public having access to these particular locations where we may have teleconferencing opportunities. I wanted to get your thoughts around that.
So this bill is actually just continuing the authority that we have at present.
Okay.
Presently, that is to expire in 2026 next year, and this would extend it an additional 4 years.
Okay.
The situation that we have, boiling it down, what we can do now in terms of hybrid meetings requires us to have a quorum in the room, as opposed to the way we operated during the pandemic and virtual meetings. This would preserve that procedure for another 4 years and also allow committees to meet fully virtually.
Does anyone, yes, Ed?
I had a question along the same lines, which is the concern. So if a board member were to elect to participate virtually, my understanding is we're required to notice the location, but also make that location accessible.
Not in the hybrid type of meeting that this authority provides. Only individuals who really, you have to work that out with your board president in advance. I mean, there's only at times your president will probably need most of you in the room. But the individuals who participate remotely in this form of meeting, okay, in California, we like to make things incredibly complicated. So we have three different teleconference procedures, teleconference hybrid meeting procedures. In this form, no, that's the point, is you would not have to, the members attending virtually would not have to disclose their location and allow members of the public to be present.
Okay. Yeah, because otherwise I'll have to do it at Starbucks somewhere.
As long as you're supplying the coffee, I think people will come.
There are things that we do for traditional teleconferences if we're going to have one of those, because those would have to be noticed.
Does anyone else have any comments regarding this bill? I think it provides broad flexibility. I think, I don't, so I guess at least my perspective, for what it's worth, I think we should take a support position. However, I'll entertain other suggestions from board members. I think it offers us opportunities and cost-cutting strategies as travel costs continue to rise. So should we take a support position on this bill?
I'll move to support it.
Okay. Is there a second?
Second.
Okay. That happened concurrently, so I don't know who was first. And is there any public comment on WebEx?
Thank you for asking, and we still have no attendees.
Okay. Ms. Hurd, could you please call roll?
Juan Armenta,
Aye.
Eric Bergeson,
Aye.
Philip DeVizio,
Aye.
Diego Insunza,
Aye.
Vasco Diankit,
Aye.
Edwin Perez,
Aye.
Bhavna Prakash,
Aye.
Deborah Snow,
Aye.
Motion stands. Thank you.
All right, moving on to the final bill, SB 641, Department of Consumer Affairs and Department of Real Estate, States of Emergency, Waivers, and Exemptions. This bill was introduced on February 20th, 2025, and is located in the Senate Committee on Public Safety. This bill would authorize the Department of Real Estate and boards under the jurisdiction of the Department of Consumer Affairs to waive the application of certain provisions of licensure requirements that the board or department is charged with enforcing for licensees and applicants impacted by a declared federal, state, or local emergency, or whose home or business is located in a declared disaster area, including certain examination, fee, and continuing education requirements. This bill would exempt impacted licensees of boards from, among other requirements, the payment of duplicate license fees. The bill would require all applicants and licensees of the Department of Real Estate or boards under the Department of Consumer Affairs to provide the board or department with an email address.
Is this prompted by the LA fires, I would imagine?
Yeah.
Correct.
Yeah.
Yes.
I'm super supportive of this bill. I mean, I think, I'm about an hour away from where those fires occurred, so I can certainly understand the sensitivities around that. But I think this bill, according to what was in the bill, by granting the authority for licensing programs to waive these requirements, I think, especially for those in impacted zip codes, makes perfect sense to me. I think we have some stuff on our website now, I think, right, Rosanna? In which we articulate to licensees about some of the waivers that the governor has put into place through executive action. So I think having a bill on the books seems to make sense to me, unless, Christy, I'm missing something.
Have any comments?
Well,
for-
yeah, I was just going to say this bill addresses situations other than that specific. That may have prompted, the fires may have prompted this piece of legislation, but I think there's an ongoing awareness of this issue in terms of the pandemic and moving forward. What happened in the pandemic was the governor delegated to the DCA director the ability to provide these kind of waivers, but this would provide the authority directly to each board.
Thank you, Michael, for that. So it would delegate the authority board for any public health emergencies such as the pandemic, which you mentioned, or any natural disasters would be included as a part of that.
Well, it would have to be, the disaster would have to meet the requirements of the bill.
Okay.
And yeah, so it ties itself to the declared emergency or disaster language. That's
Okay,
longstanding language in the government code.
Okay,
Yeah.
thank you.
I was just curious though, so, because the way I understand it is when the governor declares an emergency, there's like a litany of things that they waive, right? And I always assumed these were on that list. So what's in here that is normally
So-
not covered by?
Not for licensing agencies.
Okay,
There are no standing waivers in statute for licensing agencies to waive those kind of requirements. So those have to be done by the governor
by the governor.
specifically.
Okay.
Yeah.
And just to weigh in on the regulation side, so whenever you're looking at a piece of legislation and it says may in it, that should be a clear hint to you that a regulation is going to need to be written by you to explain exactly when you may do something. So in this situation, the analysis, I just want to point out, says there would be no fiscal impact, but if you have to implement it, you need to do regulations, applications, forms. There will be a fiscal impact to you. I don't know what that would be. It may just be minor and absorbable, but I do think that you would have to do, undergo a careful review of what you're going to waive or not waive and what the process would be and what the criteria would be to be eligible for the waiver, the timing of the filing, how long it would last. And there's also a provision about requiring an email. I don't know, and I have to go back and look and see if all of your applications require an email or if it's optional, because there was a period of time where we gave people the option to provide or not provide their email. We weren't going to require people to have email addresses back in the day when people weren't as technologically savvy. We weren't going to make you go out and get an email. But so those applications would need to be updated to put those requirements in. So just think about that as you're looking at legislation. that you have an idea of whether you support the policy, but also the implementation part of it.
So that's a great point, Christy. Thank you for bringing that up, because in the bill, it says there's no fiscal impact, right? And so that's a little misleading when you kind of think about that. And thank you for providing that context to the board. So should we, as board members, given Christie's kind of analysis of this bill, should we take a watch and see approach? Okay. Thank you. All right, Ms. Dillon, thank you. Really appreciate that. All right, so going to item number 16 on the agenda. Agenda items for the next meeting. As I mentioned earlier, we'll be bringing up the topic of practice agreements, and I will articulate that in the next agenda. Are there any additional items that the board would like to see on the agenda for next meeting?
Yes, as the medical, could we have a little rundown of how our complaint process works? How we notify consumers and when?
Great suggestion. So maybe we can kind of go through our process for reviewing, filing complaints, and how we reach out to the folks involved in that. Okay. Mhm. Any other comments or suggestions? All right, so we will be entering into closed session. And so I guess I need to do one more. Are there any public comments? I should say that.
This is the moderator. Thank you for asking, and we have no attendees.
All right, so I have on my watch 11:04. I'm sorry to have kept you so long. I would try to be a little bit more expedient next board meeting, but it's been a pleasure. So we're now going to move into closed session. Madam Moderator, could you please help us to facilitate that, or do we need to do anything for closed session?
So this is the moderator, and my understanding is you are all in person. So at this time, I believe I will simply close the WebEx, and you can proceed into your closed meeting in person.
Or should I have a statement for the closed session?
That's correct. When we should just go ahead and we will be adjourning from closed session.
Yep.
So we don't need to, if you're a member of the public, which I don't think there are any, this concludes the open portion of the meeting.
Yep.